Good afternoon, everybody. Welcome to session 11 of Principles podcasts from CASCAIDr. Today, we're going to look at a two-part part of the series. It's called Abiding by Human Rights, and then with the caveat, properly understood. This week, we're going to look at Articles 3 and 8 after refreshing everybody's memory as to how human rights work in this country. And then next week, we'll be looking at Articles 5 and 9 and some of the problems about human rights being under attack at the moment. So I hope that that will be very relevant for you. I'm not going to talk about general human rights. I'm going to talk about them in the context of health and social care. So let's just do a refresh as to where human rights fit into the UK's legal framework, in the hierarchy, as it were. When we did the first session, we looked at just generally how law works in this country, but I want to remind you that we've got a constitution in this country, even if it's an unwritten one. At the top of it, we've got this. We have got UK statutes and regulations, and we call that the notion of parliamentary sovereignty. Whatever the legislature passes becomes law in an act of parliament, and then acts of parliament provide for regulations underneath them. And I've put these at the top because there are some statutes and regulations that you would look at and you'd say, well, that really is crystal clear. And having said that, you would therefore know that if human rights principles didn't fit with those crystal clear words in the acts of parliament that you'd identified as being crystal clear, well, there'd be a problem then, wouldn't there? And you'd need to know which one trumps the other. So it's really important to understand that beneath crystal clear statutes and regulations that Parliament could still pass if it went even madder than it currently is, there are human rights principles in general and European human rights case law from a court in Strasbourg called the European Court of Human Rights. And then underneath that, it's very interesting, we've got UK statutes and regulations that are not crystal clear. And what do I mean by that? I mean any act of parliament or regulations with what you'd call woolly content that could be read one way or the other. And the way we've managed to live with parliamentary sovereignty, but say that human rights are like one of the most important things in this country, is that we have a principle in our Human Rights Act that says any act of parliament, and that's bound to include the Care Act, the Mental Capacity Act, etc. Any one of those with what you'd call woolly content is legally obliged to be read down to comply with human rights principles, unless to do so would actually murder the language. So, for instance, if the language said black and the actual human right principle required it to mean white, you wouldn't be able to pretend that black meant white. But if, for instance, the legislation said grey, and you could work out that human rights could be read as meaning grey, and then there was an expression in the statute that said light grey or dark grey, you could imagine stretching the language of that statute so that it could be read consistently with human rights obligations. Below that, we've got all previously decided case law in the United Kingdom. And below that, we've got every other kind of instrument that comes out of our government, such as directions, guidance, local policies, and even performance targets. Each one of these things is governed by the thing above. And that's really important for working out whether a person's got a good human rights point to make, or really, although they are right that they've got a good human rights point, it's not going to be able to go very far in this country's courts because they are blocked by a statute that is absolutely crystal clear. When that happens, the only point of going up our court system, if there is a crystal clear statute saying whatever your human rights are, it's not going to make any difference, The most anyone can get out of that is a declaration of incompatibility. Whereas these other woolly statutes can be read down, manipulated, and should be read down to require behaviour from public bodies that is consistent with human rights. So that's quite tricky if you're not a lawyer, but it is how our system works. So where do these human rights come from, and why is it hard for councils to be done for a breach of human rights? Well, originally they came from Europe, but not the European Union, or what we used to call it, the European Community. They came from the European Convention on Human Rights in the 1950s. And then they worked their way into our own legal system through a statute of our own country called the Human Rights Act, incorporating what had already been settled and working for numerous countries, and not just countries in Europe, you may be interested to hear, but countries further afield. The thing about that, though, is given how old the convention is, and given that it came out after the war, we've only been given old-fashioned and traditional basic rights, such as freedom from inhuman and degrading treatment, not what you'd call modern rights, what people call socio-economic rights, like the right to a living wage, for instance. There's nothing as trendy as that in the European Convention. Even the rights that we have been given in the Convention and now in our own Act tend to be woolly in their wording. Let me give you an example. The human right that people think of as relating to their home and their family and their private life actually is a right to respect for those things. Well, what the hell does respect mean? It's ambiguous, isn't it? And that's what you've got to be aware of. So even where there is a human right whose scope fits the issue in question, you read on and you find that there's often some woollier exceptions or restrictions to those rights themselves. And that makes sense if you can force yourself to think about it hard, because one person's rights are another person's duties or responsibilities. And that costs everyone money, public money, quite often. So there's always a balance to be had. And then finally, there's a 1-year time limit to sue anyone for breach in UK law. So when you put all of that together, you could, if you're a cynic, think that public bodies have the law on their side and that they're being given the benefit of the doubt. But equally, you could see that human rights would be a lot more controversial than they already are if they went further. So here are some classic human rights hugely relevant to arguments that you might be having with your council or your ICB. Article 2, a right to life. But you have to understand that that's not a right to be kept alive, no matter what the cost or the risk. It's merely a right not to be unlawfully killed by the state. So in England, you wouldn't think that that is going terribly far, would you? Article 3 is freedom from inhuman or degrading treatment. Article 5 is one's right to liberty and security. And if you think about it, deprivation of liberty safeguards, and the whole problem that we need to make best interests interventions for people who lack capacity, otherwise they'd never get any help from the state. Those are two sides of one coin, the right to liberty on the one hand, and the right to security of your person on the other hand. And then Article 8, one's right to respect for one's private and family life and one's home. This is not a right to a home or a right even to stay at home if one wants and needs funded care at the same time. Article 9, a right to respect for one's conscience and religion. And you would think, well, what's that got to do with social care? It's got to do with social care because if you are, in fact, a Muslim or if you're Jewish and you have special dietary tenets of your religion, then putting you in a care home where that will not be respected is not such a cool way for the state to discharge the Care Act. Putting you in a care home where that is possible, of course, is likely to cost more. And so that's the problem. Article 14 is freedom from unjustified discrimination in the delivery of all of these other human rights. And that was hugely important in the Norfolk charging case. And that was the basis of that. Could I ask people just to check that you're muted off at the moment, because I am trying to mute you all. And as you come into the session a bit late, it isn't working for me that I am managing to do that. I hope that I have done that. So when we brought in the Human Rights Act, I'm wondering if we know how it changed the laws that we already had in place. Section 2 of the Human Rights Act says that our judges have to start from the position that in a human rights case, they're going to apply European human rights jurisprudence, case law, and precedent. And those rights and that approach from the European Court, although I think it's fantastic that we've got it, it's never been set very low for fear of discouraging underdeveloped and not very affluent countries from signing up to it. But at least we tell our judges in Section 2 that they must use European court standards. And then we've got that duty to read those woolly statutes that I've just mentioned down so that they can be human rights compatible wherever it's possible to stretch or shrink the wording. Where it's not possible, where the language used is crystal clear, then the law is that whatever statute that is, it trumps human rights principles. If the victim goes all the way up the court system and gets a declaration of incompatibility, then what sometimes happens is that the government changes the law. In terms of an individual being able to get rid of their nearest relative under the Mental Health Act, that's a perfect example of how that happened. The words in the old mental health provisions could not be stretched. They were crystal clear. A mentally unwell person did not themselves have the right to choose their own nearest relative. And when a declaration of incompatibility was acquired about that by somebody challenging that situation, the law was changed. But it was changed for the future and not for the past. The change is not retrospective. And then the heart of the Human Rights Act is this. Section 6 makes it unlawful in general for public bodies to act inconsistently, to breach, that is, human rights, unless they are positively forced to do so by the language of a crystal clear statute or the regulations. And what's extra is that, especially unusually in public law, human rights damages are payable. So there isn't just the embarrassment of having your decision overturned, but relatively small amounts of damages in line with the tariff from the local government ombudsman can be awarded. So it means that in a case where you're putting forward a complaint to your local authority, or you are using legal process to use judicial review to challenge a Care Act decision or a health service decision, you can add human rights breaches and point out respectfully that they will lead to the potential for a damages claim if the case has to go ahead. I've got some examples of how human rights have been squished into the Care Act. The Human Rights Act was brought in 1998. The Care Act was brought in 2014, in force in 15. And the MCA was brought in 2005, in effect in 2007. So those bits of legislation have had human rights principles driven into the drafting in the first place. And that's why you don't see a human rights challenge in every single judicial review about the CARE Act, because it's already regarded as being 99% human rights compliant. So, for instance, the involvement provisions in the CARE Act in Section 9 or in Section 24, etc., the involvement provisions and the rights to advocacy are all part of Article 8 jurisprudence, and for advocacy, Article 14, so that incapacitated people or people with less than full cognitive power are not discriminated against. We've also seen that the whole of the CARE Act guidance is built on public law principles. They themselves reflect human rights regarding respect for core human values. So even if the words human rights don't appear in the CARE Act guidance, public law principles, which this whole course is about, are usually human rights aware. Then you've got the Mental Health Act, and you've got that seeking to balance the rights of the many and the rights of the few people who are seriously mentally ill in our society in terms of safety and care. Everyone would agree that that's necessary in a civilized society, I am sure. The Code of Practice under the Mental Capacity Act is full of references to human rights abuses and what's called tortious wrongdoing. The idea that if you touched a person without capacity, you would be assaulting them because you haven't got their consent. But because the MCA is human rights compliant and provides for a solidly sensible way of deciding who lacks capacity, and then requires best interest consultation before anybody does touch anybody else, it is actually human rights compliant and solves a big problem. And the Mental Capacity Act even ensures that people who can't be regarded as capacitated can get themselves to court with non-means tested legal aid. And that's because they can have a relevant person's representative or an advocate or a litigation friend get them to court, to the court of protection, so that they've got access to the legal framework. So that should make you feel a bit better about how good the legislation is. It's just that if nobody knows about it and nobody engages with it, and local authorities don't think of having checklists about it, then in fact we all go down the Swanee. So here is a typical checklist for safer policy and decision making for all council and ICB's decisions. And if you're not from a council or from an ICB, don't switch off. Think about turning these points around for when you're writing to the council to say, I'm not sure that your decision is human rights compliant. Did you take this into account? Did you take that into account? It's just a question of being limber with written language. So the first thing for a council to think about is what they're about to do or to decide, does it overlap with any of the human rights that are included in the articles that I have mentioned? Because it's only if a local authority is engaging in the sphere of a specific human rights, that a human rights case can be put forward. So if there is that overlap and that engagement with a specific human right, then is what is being planned by the local authority, is it first and foremost legal under UK law? Then, if so, is it within one of the woolly restrictions applying to the particular human right which has been engaged? In particular, the restrictions under Article 8, for instance, include the protection of health and morals, the prevention of crime and disorder, and the protection of other people's freedoms. So if what the local authority is doing is driven by one of those woolly restrictions, you might not like what they're doing, but it's not likely to be unlawful. Would you say that what you're about to do as a council or an ICB is necessary in a civilized society? And is it proportionate? Are you using a sledgehammer to crack a nut? Think about the way blanket policies, for instance, just admit of no nuance, no exceptions. That would be a difficult thing to justify. If a local authority is really not sure about these features of their decision making, they still have one let out, which is to point to a UK Act of Parliament that is perfectly clear on the matter, or else research whether there's been a derogation from the European Convention notified by this country. In other words, the government claiming an exemption from the European Convention for a short, specific period. There were some derogations during COVID, let me assure you. Just to give you some examples around mental health and people in psychiatric facilities: dignity in mixed-sex wards, body cavity examination of visitors in case they're bringing things in, access of people's children as visitors, the contacting of the nearest relative unless not reasonably practicable, and the means by which a person who's not only ill but lacking in capacity ever gets any of these rights of challenge if they've got nobody to act for them, and mental health advocates expect consent. The problem there has been solved by making it a manager's responsibility within the hospital system, in the psychiatric hospital system, to ensure that people's cases get to tribunal, even though they may have no capacity to be noticing that they are due a tribunal hearing. And of course, Mental Health Act advocates are expected to provide some form of robust support, even to a person who can't consent to having an advocate. The trouble is, because Mental Health Act advocates are not experts in capacity, if they meet somebody in a psychiatric hospital who says, "Bog off, I don't want to see you," they take that to be refusal of consent, instead of thinking that it may be somebody's mental health condition that is actually negating their capacity to figure out what an IMHA is even for. And then, of course, the right to liberty versus every patient's desire to consent to very stringent conditions of restriction in order to obtain discharge via a CTO or some other regime. And then rights regarding consent, or the lack of rights to refuse consent to medical treatment for mental health conditions. I'm not saying all of these things are human rights. I'm saying that all of these aspects of being detained in hospital give rise to these issues of human rights. You may be specially interested to know that all providers of care who operate under the Care Act, in other words, commissioned by local authorities or funded by way of direct payments, count as public bodies under the Human Rights Act, even though they may be public limited companies or limited companies or CICs and not part of the state at all. And the history of that is that we've had litigation in this country that found that care homes were not exercising a public function and therefore couldn't be made responsible for human rights. And the government legislated to make that definition in the Human Rights Act cover care homes as well. And that's been carried into the Care Act. And you can see there, I won't spend time looking at it, but Section 73 of the Care Act makes it totally clear that all providers of regulated care who are funded through local authority money owe human rights as if they were part of the government or local government. So that's really important. And you may well say to me, some of you who've got NHS continuing healthcare clients, what about those providers? And the law is the same for NHS providers, or rather, providers who are private and who are funded by the NHS. There isn't this equivalent in the NHS Act, but all such providers are providing services through the Secretary of State and are therefore shouldering a public function. And that's totally clear. So here are some examples of cases that go back many years, all of which are to do with health or social care, some of which we've already looked at in relation to some of the other Public Law Principles podcast episodes. But in particular, there's Elaine MacDonald with the incontinence pads. There's Enfield and Bernard, where a couple got about £10,000 worth of damages for a breach of human rights. And then there's Rachel Gunter's case. An ICB found liable for ignoring human rights in relation to her need to be at home, or rather, more than her need, her want to be at home, but also the very great benefits that it was providing for everybody, that she was at home, good for her family and good for herself. And that outweighed the need for the ICB to save money. Then there's a case about intimate relationships chosen by people with learning disabilities, but with sufficient capacity to make the choice to have sex. And most recently, a case called Aburas about the way the Human Rights Act can save even people with dodgy immigration status from being excluded by the Care Act from receiving services, if they are not merely destitute, that is. Unfortunately for Mr. Aburas, he was found to be merely destitute, and therefore he could not rely on the Care Act. So if you're interested in searching for any of these, you can go onto our website and use our search box, okay? That will help you. As I said, Article 8 is the most relevant article of the Convention, and we are still joined up to that, please note, despite Brexit. We haven't fallen out of the Convention. And Article 8 says everyone has the right to respect for their private and family life, their home and their correspondence. And it requires that there shall be no interference by a public authority, that's a council or an ICB, with the exercise of this right, such as is in accordance with the law, that means the law in this country, and is necessary in a democratic society. And then there are all the excuses for giving someone less than a normal amount of respect for their privacy. One is the interests of national security. I guess you wouldn't be surprised about that, but then here are the others. These are the further caveats or restrictions to Article 8, the qualifications or justifications for some interference by a public authority when there really is no other option. These are justifications which could have been written specifically with the COVID crisis in mind, given the problems it then presented. And if I show them to you, you'll see what I mean. So these are the other restrictions. Public safety, the economic well-being of the country, the prevention of disorder or crime, the protection of health or morals, and the protection of the rights and freedoms of others. So if you think about visiting regimes and you think about vaccination expectations and presumptions, and you think about PPE, all of those things which were fresh interventions in our right to live our lives as we choose, they were largely likely to be justifiable under these restrictions to Article 8. Where it says the economic well-being of the country, that is usually read to mean the economic well-being of the geographical area now. So, for instance, the council that is trying to balance its budget. But when I mention its budget, I really want you to grasp, I do not mean that a local authority can just say, we've got to breach human rights because we can't afford not to. That is not how human rights works. To be able to say that the money is a really big issue is one thing. But to say that it becomes the be-all and end-all of the balancing that has to be done is not allowed. Local authorities still have to bear in mind that for some people, there really will be only one way to meet their need, literally only one. And then the cost of that does not matter, and the cost of any other and the state of its resources cease to be relevant. So necessity, in terms of necessary in a civilized society, in a democratic society, that's where the reference to proportionality comes in. So if a local authority is going to be very mean in its care package, or an NHS ICB is going to say, you have to go to a care home, they'll be able to put forward the pressing social need to use their money very carefully, but it will not be the only determinant of care planning. And so just because a financial impact is inevitable, it doesn't mean that getting that saving becomes the determinant for the public body. I think during COVID and now, the problem is not so much the money. Of course, the cost of care has gone up, and of course, local authorities particularly have got less money. But in fact, we were talking about it at the beginning of the session before I put the recording on. Everybody in this session will be, if they're working, aware of the struggle that we're all living with of achieving anything because nobody has got enough staff. It will be the absence of staff or trained and experienced staff that we're all suffering from. And you can't just make a court order and magic up those staff from nowhere. So what's worrying me at the moment is that if a human rights case was put forward, judges would end up saying, I don't really feel I can make a court order because I can't be convinced it's going to help. And so that's why we don't feel so hot about being the organisation that brings a test case that ends up that way. You can understand why all lawyers would be anxious about that. So this goes on to talk about what proportionality is really all about. It's another aspect of unreasonableness, which is a public law principle in and of itself. And this slide assures you why contractors delivering services for the NHS are as bound by the Human Rights Act as care homes and other providers who are just providing to the council. This slide is the first one on Enfield and Bernard, which explains that when Mr. and Mrs. Bernard contended that Enfield was treating them inhumanly and degradingly, the court actually said no. It was very, very sorry for Mr. and Mrs. Bernard and didn't like the state that they'd been left in, of which you'll hear more before the end of this session. But they said, using European court jurisprudence, which if you remember they've got to do, ill treatment must attain a minimum level of severity and harshness if it is to fall within the scope of Article 3. The assessment of this minimum is, of course, relative, depending on all of the circumstances of the case, such as the nature and context of the treatment, its duration, its physical and mental effects, and in some instances, the sex, age, and state of health of the victim. And they pointed to a case where a severely disabled woman had been imprisoned for 3 nights for contempt of court, and she was left without her wheelchair, and she was an amputee. And that was regarded as a case of inhuman and degrading treatment. But for instance, in Enfield and Bernard, the fact that Enfield didn't set out to humiliate or debase the applicants was really important. But to detain a severely disabled person in conditions where she is dangerously cold, risks developing sores because her bed is too hard or unreachable, and is unable to go to the toilet or keep clean without the greatest of difficulty, that does constitute degrading treatment contrary to Article 3. So you can imagine, of course, that for some people in psychiatric hospitals who have hit the press, the conditions in which they are being accommodated are regarded as degrading by them and their relatives. But then when the NHS says we can't give anybody their normal clothing because they will tie a ligature or they will attempt suicide, you can perhaps begin to understand how the premises, the room, or the cell, as it is sometimes called, end up becoming more and more Spartanly, if there is such a word, furnished, and why the individual is not left with their brush or their comb or their cutlery. I mentioned in previous sessions the McDonald case, incontinence pads for someone who's not incontinent, and I mentioned that in the context of Article 3. Article 3 was not made out in the Elaine McDonald case, and even Article 8 she struggled on, other than when her care plan actually said she was supposed to be being given assistance to reach the commode at night. The judges said Article 8 cannot be considered to be in play every time an individual's everyday life is disrupted, but where the state's failure to do stuff interferes with the individual's right to personal development or their right to establish and maintain relations with other beings and the outside world, that's where you're in an Article 8 situation. So it talks about the need for a fair balance and the margin of appreciation that the state is always given. And it ends up saying never more so than in cases where there are very limited state resources. In other words, the money for care and attention. And that's why it's difficult for a social services or a healthcare client to win a case involving breach of human rights, because one person's care package always means that somebody else is getting a smaller one. In relation to dignity, the judge said, I have the greatest sympathy for Miss McDonald, but I do not think that Kensington and Chelsea was deliberately doing her wrong. The error that they made was not born of any lack of respect for her dignity, but of a concern, even at the time it was wrongly executed, to do the difficult balancing task with the very limited resources available to it. And there we have it, ladies and gentlemen. If you want more human rights for adult social care and health clients, you've got to pay more taxes. You've got to find a way of finding a party that isn't afraid of saying taxes need to go up. You're going to love the Gunter case, though, because this was a case where the argument was about where should a CHC client be cared for. And the judge was really impressed at the care that the family carer was being able to provide to Rachel Gunter, even though she qualified for CHC. She'd had a remarkable improvement in her condition. And that didn't mean she wasn't eligible for CHC on the basis that she'd stabilized. It meant that she was doing better at home than she could hope to do elsewhere. The NHS said, well, look, if we spend this much money on her and then we didn't spend this much money on her because she could be in a cheaper setting, we could then do this, that, and the other with it. And the judge said, nah, I'm not interested. The judge said, I do not regard evidence of the benefits that could accrue from the expenditure of the sums which could be saved as helpful. It cannot mean that someone such as this woman should receive care which does not properly meet her needs. And there is a key thing. The contention was that she needed to be at home, not just that she preferred to be or wanted to be. Cost is a factor, the judge said, which can properly be taken into account. But the other factors suggest that to remove her from her home will require clear justification. Why aren't people challenging CHC care planning decisions all the time on the basis of human rights and needs? Because they can't find a lawyer. And without remedies and without lawyers, people have no rights. Then there's the case about a young woman who'd been having sex with a man for 11 years. Nobody had stopped them. When she went into supported living, she was told that it was house rules, that she couldn't have her boyfriend come to stay. No doubt that was sensible, because he didn't have a very nice background in terms of his criminal history, and no doubt it was considered a risk. But then we come slap up against the problem, don't we, ladies and gentlemen, that supported living is supposed to be the person's own home. And if you were told who you could have sex with in your house, I suggest that you wouldn't like that very much either. The local authority said, well, what are you saying we've got to do? Have we got to get them a hotel room and listen outside, or what? And the judge said the local authority cannot seek to toll the bell of scarce resources, because the additional financial burden which doing this properly may impose is comparatively modest, given the overall cost of its provision for Miss MM and the enormous importance of the human right that is in play here. Your sex life, if you've got capacity, is too precious in human considerations to give way to merely fiscal considerations. This was a case as long ago as 2007. So the local authority effectively had a choice. They could either keep MM in supported living, but facilitate her going somewhere else to have sex, no need to listen at the door. And secondly, the other choice was to not have the rule in supported accommodation, which counted as her own home and in respect of which she had a tenancy. To seek to do one without shouldering the burden of the cost is a disproportionate interference in MM's life, and that makes it a breach. This case here is detailed, but it is a case that talks about manual handling in the context of very disabled people who needed manual handling to go riding or to engage in other leisure. And the point of putting this in is for those of you who end up being told that either a council doesn't do manual handling at all, doesn't commission manual handling, or won't pay for the activity if it involves manual handling. The judge went on to say that it's not feasible for any social care council to ban manual handling or not commission it. It may be necessary because it may be somebody's actual need under the legislation related to health and care. And the judge said this at the end: part of the positive human rights obligations of the state is to take appropriate measures to ensure that a disabled person is not so isolated as to be deprived of the possibility of developing his personality in society. The more disabled you are, the judge said, the more dependent you may be on leisure and recreation to have any opportunity to develop your personality within the community. And the judge said, you can't assume that manual handling is even regarded as undignified by some people. It may be the more dignified thing. And that's true for care homes, isn't it? A person may feel that they have a better life in a care home than in their own home, particularly if supported living involves shared care around the clock. So the point was that this is a fantastic case on the human rights of people with disabilities to have a proper decision made about their leisure and recreation. And then finally, we come back to the Enfield and Bernard case, where you can read here the terrible state that housing and social services left Mr. and Mrs. Bernard in their unadapted and inappropriate housing, where the lady was wheelchair bound but couldn't use her wheelchair. She contended that leaving her in that state with the inadequate care package effectively involved robbing her of her role as wife and mother. And on that basis, she argued that it was a breach of Article 8. And the judge ultimately said he agreed. And in this case, the appropriate damages figure was £10,000 to the couple, £8,000 to the second claimant, and £2,000 to the first. So that ends the lecture for today. And that sounded a bit biblical, didn't it? I'm going to let people unmute now. Let me do that. People can now unmute. Would anybody like to ask any specific questions about human rights? I ought to be able to see you if you put your hand up, or I ought to be able to see you if you just unmute. Okay, anybody wanting to ask a question? Go for it, Mary. Hello.
Yes, so you're saying this human right actually impact on people providing under direct payments?
Yes, so human rights are an obligation of public bodies.
Okay.
But the CARE Act makes human rights an obligation of registered care providers who are commissioned, or, this is key, providers who are providing local authority funded services. Okay. And of course, when a person gets a direct payment, that is when they would be getting local authority money. Right. So if a care provider who is registered owes an obligation as if human rights applied as much to them as an emanation of the state, as if they were a local authority or an ICB themselves.
Oh, okay. We have to be careful with our staff then.
Yes, I'm not quite sure whether that applies to those organisations that are providing services to personal health budget clients, however. So that's an interesting thought for me to go and look up.
Okay, thank you very much.
Any other questions from anybody, please? Okay, well, let me just invite you to remember that if you want the PowerPoints, we ask you to sign up to our roundup, and that's a simple one-off charge of £25. If you've paid that and you have not had the PowerPoints, then we owe you an apology, but there is somebody called Aidan Miller, Aidan spelt with an A at the end rather than an E, Aidan Miller at CASCAIDr.org.uk. So chase him, please, rather than chasing me. I'd be really grateful. The other thing I'd ask you all to do, please, is to spread these around as much as possible. These are public. They are free. I do not care who these podcast links go to. So we have a channel on YouTube, and we provide you with those details so that you can listen to them again, and so can other people. Emma, do please unmute. Hello.
Hello. Sorry, I just wanted to ask one question. If you're receiving FNC in a nursing home, would that be enough to instigate the Human Rights Act?
It would be. It would be. And I'll tell you for why. The FNC portion is direct from the health service for the discharge of the obligation to provide the person with registered nursing in a nursing home. So it engages human rights. There's a nice argument about whether it engages the personal care side if the organisation is private. But since the NHS will be paying potentially for the whole of the package if it's a CHC person, then that wouldn't matter. But in relation to a local authority or a private client who's in a nursing home, the nursing home certainly owes some human rights in relation to the FNC portion. Okay.
That's great. That's really helpful. Thank you very much.
Oh, all right, then you're very welcome. I'm just checking in the chat because there is a question from Julie, and I wish I hadn't looked, Julie, because you're going to say The question is, are landlords under the same human rights conditions as the supported living support provider? And the answer depends on the type of a landlord. If it's a private sector landlord, no. If it is a registered housing association, which it generally will be, then the answer probably is yes. But if that registered housing association is only providing tenancies and isn't bound up in some other way with the local authority, like being part of an arm's length management organisation for homelessness and public sector housing functions, then that could be a housing association landlord who is not governed by human rights. Okay, that's a difficult question, but I think I made a reasonable stab at it unwarned. Okay, thanks very much indeed. See you all again next week, I very much hope.
Thank you very much. Thank you.
Cheerio. Bye-bye.
Thanks.
Thank you.